Mr. Kenny.
My lady, you said you would be prepared to sit tomorrow afternoon. We've discussed timetable. My aim is to finish in an hour. Then Mr. Eaton will take as much of the time available as he needs, and I'll expect to reply tomorrow afternoon. I had got as far as showing you Dunlop and Hendel Steel and the question whether a contract for payment during the course of a contract of construction where payments are made against certificates is a contract under which there are accrued debts at any stage prior to the issue of the certificates. And I said on the authority of Dunlop and Hendel Steel, that was not the case. Before leaving that topic, I just want to anticipate Mr. Eaton's submission and look at paragraph 72 of his skeleton, which is at page 138 of the appeal bundle. And what he says is, there was a substantial amount of work done here. And then he says, it seems implausible that the parties intended that P, that is the yard, should not acquire any right of reward at all unless the surveyor certified the work. The more natural view is that P's reward was earned as the work was done. And the answer to that is, insofar as it's implying that one's commercial expectation would be that there would be payment or reward as the contract went on, well, that's precisely what the contract did provide for. It was payment cash against expenses against a series of interim certificates. So if the point that's being made is, well, hang on, you wouldn't expect no accrued rights in the yard prior to the very end of the contract, then that's not what the contract was providing for. The contract provided for periodic payments against expenditure during the life of the contract. If, on the other hand, what he's saying is you wouldn't expect the yard not to have any accrued right even in between the issue of the certificates. So in other words, 2 months have gone by, I've done X amount of work, and you ask, how about this before next month's certificate? Have you got any accrued rights? The answer is no, you don't, because nobody has yet certified that the work has been properly done at a proper cost. So the two constructions that could be put on this neither make good the point that this is an arrangement, or that the Panamena contract, as we contend it is, i.e. as a contract where there are no accrued debts until both certificates have been issued, is one contrary to one's commercial expectations. And even if I were wrong about that, the idea that there is some accrued but not payable debt doesn't seem to be an answer to the commercial point that's being made. I mean, of what benefit is it to the tribunal, to the yard, to know that it has an unconditional right to payment, but not one that is actionable until the surveyor has issued the certificate? Sort of completely abstract benefit. All right, so our first submission in response to Mrs. Justice Dias's conclusion that the Panamena contract was one where the CIB certificate made the debt accrue and the owner's surveyor certificate was only dealing with payability is that's just not a sensible right construction of the contract between the yard and the owners in that case, for the reasons I set out. Our second submission was, well, even if the judge was right that the owner's liability to the yard in Panamina was a debitum in praesenti, solvendum in futuro, there's no reason, no principled reason, to apply the abacha principle to that situation and not to apply it to a case where the actual accrual of the debt depends on the certificate. What justification could there be for saying we'll apply the abacha principle if the surveyor's certificate only goes to the time of payment, but will not apply it if the surveyor's certificate is a condition of the accrual of an assignable or garnishable debt? I mean, either way, the claim for the money is not actionable without the certificate, or at least is not actionable without the certificate unless the abacha principle applies. So
there's an important distinction between the two circumstances. In one case, you have existing rights accrued. In other, you don't have any existing rights, subject to application of the principle dispensing with the condition.
Yeah.
And if the juridical basis for the principle were the Newmont principle of what's the deemed contractual intention, one can see that it might be more readily regarded as the party's contractual intention, that if you've got accrued rights, you should dispense simply with something which is a condition for payment, than something which has the effect of vesting rights which wouldn't otherwise exist. And there seemed to be a hint of that in what Mr. Justice Foxton said in his Rolls-Royce case, that the case is all the stronger for applying the principle.
Well, he
he didn't put it on that basis, but he seemed to think it was a stronger case if you were dealing with accrued rights.
Yeah, I accept that the work that the principle is doing is less in the case where all you're doing is effectively implying a term as to the time of payment. And in that context, you might think of the Karen Vartis, where the freight was to be paid on arrival, and but had been earned on shipment, and the court said, well, all this means is we have to imply a term as to where, if the ship if the ship never arrives, the debt will be paid, and we just apply a reasonable time. So I accept it's a sort of it's an implied term that is more that is readily implied, but nevertheless, my point is that from the perspective of the yard, the situation that it finds itself in is identical, whether the effect of the contract is as Mrs. Justice Dias would have it, or as we say it is. It's done work, its right to be paid depends on having the surveyor's certificate. And it seems very odd that in a case where the contract is expressed in a way that it has an accrued right, and the certificate is just effective as to term of payment, that the breach of the owner's breach in refusing a certificate would mean that it can get the money. But if the contract was expressed very slightly differently, so that its right to payment depended on the certificate, that somehow the same principle couldn't be applied.
I understand that, but it may not be right to say it's in exactly the same position if one takes into account the special rules that apply to accrued debts, such as an ability to assign them. And it could factor the debt, couldn't it? If it had someone who's prepared to pay for
Well,
it.
you have.
It's not quite in the same position.
Yeah, I mean, it's not able to assign the debt, but for practical purposes, I'm just looking at it from the commercial perspective of a yard. It's done the work. If you said to the yard owner, "What do you need now?" I need a certificate to get paid. Well, if your legal team had arranged for the debt to be accrued but not payable until issue of the surveyor's certificate, well, if Dr. Telfer withholds the certificate, that's no obstacle. Don't worry, you can be paid. If your legal team had said payment depends on getting a certificate from the surveyor, sorry, we can't help you. You've got to sue for damages. Anyway, you see.
I understand the point of time.
Okay, so our second critical authority, William Corey against London Residuary Body, and Mr. Eaton teases me that this is not a case that's had the kind of star billing that I'm saying it deserves until now. And I can only reply that the real tragedy here is that we've lost Mr. Justice Hobhouse's decision at first instance. That would have really clarified this case and made everyone's job a lot easier. The case is at tab 20. It's a contract for the handling and removal of rubbish, one clause of which, clause 19, which is set out at page 326 of the bundle, provided for described as non-index linked fluctuations, which referred to variations of wages and changes in methods of working, and provided for the contractor to notify the council, that was the GLC, of such matter, and if these events shall result in an increase or decrease of cost to the contractor, then an allowance equivalent to the net increase or decrease of cost as certified by the engineer, who was the GLC's employee but in the same position as Dr. Telfer, shall, subject to the provisions hereinafter contained, form an addition to or deduction from the amount otherwise authorised. Authorised for payment, I should say. The contractor, Corey, submitted claims under that clause 19, which were supposed to be authorised within 7 days and would have become due for payment 14 days afterwards. But the engineer I think in a quandary because the GLC was being wound up, just didn't deal with the claim. And at first instance, in front of Mr. Justice Hobhouse, the GLC argued that the engineer's certificate was a precondition to any liability for the debt, precondition to the accrual of the debt. And one sees Mr. Justice Hobhouse's setting out the respective contentions of the parties at 327. And what Lord Donaldson then says at below the quotation from Mr. Justice Hobhouse's judgment is, Hobhouse J then examined a number of authorities and concluded that the engineer's certificate was not a condition precedent to liability, and that Corey could establish its claim independently of such a certificate by obtaining an arbitral award or judgment. Now, at that point in the summary, it's not clear on what basis he said that. I mean, whether his decision to that effect was founded on the GLC's wrongful failure to issue the certificate that the engineer should have issued. So all you know is that, having considered the matter, he's decided that it's not, the existence of the certificate is not a precondition to the debt accruing. On appeal, the GLC say, well, we accept that the debt accrued, but it wasn't payable. It wasn't payable because, although it may have fallen due, nobody knows what the number was until the court has exercised what the amount of the debt was, until the court has exercised its role in determining what the quantum of what the value of the debt was. And it was that issue, whether the debt was payable, which was decided by the Court of Appeal. And the critical part of this decision is at page 328, second paragraph, second and third paragraph. And it's probably best that you just read those two paragraphs, but I just say this, that what Lord Donaldson says very much suggests that Mr. Justice Hobhouse's decision at first instance was saying, or was to the effect that the breach by the GLC, breach of contract by the GLC in failing to provide an engineer's certificate, was the circumstance which had the result that the debt accrued due. And I say that just because he says, as is now admitted, an omission for which, so the engineer never certified it before 1st April 1986. This, as is now admitted, was an admission for which the GLC was vicariously responsible. That being so, the LRB, that's the GLC successor body, is unable to rely upon this as a defence. It goes not only to the issue of whether the payment was due, but also to the issue of when it became payable. So that we take to indicate that the decision at first instance was you can't rely on the absence, in circumstances where you're responsible for the engineer not issuing the certificate, you can't rely on it as a defence to the debt falling due. And then what the Master of the Rolls says is, and here in the Court of Appeal, I'm going to say, it also doesn't give you a defence to the effect that it didn't become payable. And when you say, what is the basis of that decision? It's a long line of cases, of which the best known is perhaps Mackay and Dick. And then explanation of the well-known facts of that case, and also of Panamina. the what do the buyers say in response to this? Essentially, as we understand it, their submission is the same as with respect to the Panamina. They say this was a case in which the relevant debts owed by the GLC were due even without the certificate.
Sorry, I'm just going back a stage.
Yeah.
I thought your submission was that in the Court of Appeal, the LRB had accepted that the debt had accrued.
Yes.
But I'm just looking at the paragraph above the second hole punch. Will the LRB seek to take advantage of the GLC's failure to issue an engineer's certificate by contending both that in the circumstances no payment was due before the 1st of April, and that even if any such payment was due before then, it was not payable before that date, which looks as though they were taking both points in the Court of Appeal.
It's not terribly clear. I agree with the reading that you, and I agree with what you say about that paragraph. But then on the previous page, uh, 327, second paragraph from the bottom, they, the LRB, accept the whole of the learned judge's reasoning, accept his conclusion, but complain that he's ignored wholly a part of their argument. That was if, which they had denied but now accept, the engineer's certificate is not a condition precedent and Corey can establish their claim by obtaining a judgment, the resulting liability will not be a liability which was both due and payable before 1st April.
Reference on page 328 could be read as you've been contending in these proceedings.
That's how I had read it.
Yes, I see. Thank you.
So the question I was about to address was, what do the buyers say about Corey? And essentially their position is the same as with respect to Panamina. They say that even in the ordinary case, in other words, putting aside any question of failure to deal with the claim, the debt under clause 19 accrued due before the engineer's certificate. All right. So forget about the Abacha principle for a minute. Even in the situation where the GLC is dealing with clause 19 claims promptly, it was not a condition of the debt under clause 19 accruing that the engineer's certificate was granted. To which we say, but that can't be right, because this is just another Dunlop and Hendel Steel case. This is a case in which the engineer's certificate is essential both to determine the validity of the claim under clause 19 and its amount. To suppose that there was an unconditional debt under clause 19 in favour of William Corey before the matter had been looked at by the engineer involves saying, well, when did that accrue? When would that accrue? Or when William Corey think that they have a claim? When they submit it, but even before the engineers had a chance to look at it?
So maybe I'm missing something, but on
Yep.
page 327 it's saying that Mr. Justice House concluded that the certificate was not a condition precedent for liability. The Court of Appeals is saying that's wrong.
It was not a condition precedent in circumstances where the GLC had refused to produce the certificate.
Oh, that's the way you're reading it.
Yeah,
Okay.
and that's why I said, sorry, that's why I said on 327 in the middle of the page, he examines and says it's not a condition precedent, and that doesn't tell you in terms why he said that.
So, yes, you
Yeah.
did say that.
Do you see? And then, but then you read over the
Say
page.
that it was following examination of a number of authorities, rather than necessarily simply by an application of contractual terms.
Exactly, and yes, I readily adopt that. And but my critical point, my lady, is over the page, the passage I showed you, where what Lord Donaldson says is that the GLC's breach in failing to issue the engineer's certificate goes not only to the issue of whether the payment was due, all right, and what that's revealing about Mr. Justice Hobhouse's decision was that the decision below was on the basis that the GLC, in breach of their contract, have failed to issue the certificate. The claim for the absence of the certificate doesn't constitute a precondition. What I'm
You spell that out, do you, on the basis that it suggests that the issue before Mr. Justice Hobhouse was whether the GLC was vicariously responsible for the failure of the engineer,
or
this, as is now admitted,
yeah,
wasn't mentioned.
and also that I mean, potentially, presumably advocates in those days were the sort of desperados they are today. In the alternative, that even if there was vicarious responsibility, that nevertheless the issuing of a certificate was a condition precedent to the GLC being under any liability. But and that's what the Master of the Rolls appears to be answering. He says the absence of the certificate and the fact that it's your breach that has your servant's breach that means there is no certificate goes to whether the payment is due and whether it's payable. So the answer that is advanced by the buyers for this case is to say, under this contract, there was an accrued debt under clause 19, even before the engineer had issued his certificate, or as the case may be, even before the engineer had failed to issue his certificate timelessly. And we say in response to that, well, this is just another Dunlop and Hendel Steel situation. It's another Panamina situation. It can't be right that there was an unconditional debt owed by the GLC to the contractor before the engineer had even looked at the claim.
Notwithstanding that that was conceded in the Court of Appeal. You told me that's how we should read it.
No, it was conceded in the Court of Appeal that once there had been a failure to issue the certificate, then the GLC could no longer rely on the absence of the certificate. But and maybe this is just illustrating, I should just let Mr. Eaton make his submissions. But the buyer's position is that this is a debitum in praesenti solvendum in futura case, and that the liability of the GLC under clause 19 accrues due at some point in time, they haven't specified exactly when, and that the engineer's certificate for which clause 19 is making provision is only relevant to the time of payment. And our submission is that just can't be right. I mean, if you have an engineer who is there to review claims under clause 19 and does so in ordinary, I mean, just test it in this simple way. I put in a claim under clause 19 for £100. You're the engineer and you say, I look at this, you're entitled to £50. Am I entitled at that point to sue for £100 on the basis that I had an accrued debt of £100 before you'd even certified? Or if the debt of £100 was unconditional before the engineer looked at it, on what basis can he possibly change it and say it's only
Well,
£50?
I understand that submission, but I thought earlier you'd submitted that the LRB in the Court of Appeal
Yeah, but
had conceded.
they
debt had
conceded that it wasn't a condition precedent once they had failed to issue the certificate. See, once the precondition to their liability, what they were saying was, at first instance, there's no liability until the engineer has looked at it, which he has to do in 7 days. And then when he fails in breach of contract to assess the claim, there's still no liability. And it's that second part of the proposition that they gave up in the Court of Appeal. They accepted that once the engineer had failed to deal with the claim, they couldn't then rely on the absence of an engineer's certificate to defeat the claim under Clause 19.
Could you could at least say, presumably, that the case proceeded in the Court of Appeal. By the time it got to the Court of Appeal, this was a condition precedent as to payment
In
scenario, for the reasons you've given.
Yeah, in the Court of Appeal, they had accepted that by reason of their breach in failing to issue an engineering certificate, they could not say that the absence of a certificate was a condition precedent, was a failed condition precedent to their liability for the Clause 19 payment.
Are you effectively relying on an implicit or explicit approval of the approach of the judge below?
Yes, I'm relying on the dictum that I've shown you where Lord Donaldson says their breach in failing to issue the engineer's certificate goes not only to the issue of whether the payment was due, but also to the issue of when it became payable. And the issue before the Court of Appeal was, could they rely on their own wrongful failure to issue a certificate to argue that the debt had not become payable? That's the point that's actually decided.
Yes.
But what he's alluding to and tacitly endorsing is the decision below that they can't rely on their own wrongful failure to issue a certificate to assert that the debt under Clause 19 never accrued due.
Yes, thank you.
Okay.
Sounds a pretty odd submission for Graham Hamilton to have made, but there we are.
So what's that?
Sounds a rather unpromising submission to have had to advance in the Court of Appeal by Graham Hamilton.
Well, I mean, it's the brave start that says, we don't challenge the judge's reasoning. He just forgot to deal with a major part of our case, which is that's the premise on which it was put. Noga and Abacha. I have set out in our written skeleton both the facts of the case and the critical passages in the judge's judgment. And I'm not going to take you through that now. Suffice to say, it is a decision which we say is on all fours with the present case. It's a case in which the debtors, putative debtors, had a contractual duty to procure the release of funds from a court. So it's procuring the action of a third party. In breach of contract, they failed to procure that action. As a consequence, the putative debtors were unable to rely on the fact that the money had not been released as an answer to the creditor's claim for the debt. The precondition to the debtor's liability, which was the release of the funds, was either deemed satisfied or deemed waived. And Lord Justice Ricks preferred the deemed waive as more consonant with everyone's expectations. Whichever terminology you used, the debt fell due when, in breach of contract, the debtor failed to procure the satisfaction of the precondition. And that we just say is our case again. And the point, the case is, as I understand the buyers accept, not sensibly distinguishable from the present case. They just say it's wrong. Can I then deal with briefly the justice of the situation? We make essentially two short points about why the principle that we've identified is not only right as a matter of authority, but right as a matter of principle and justice. The first is, it is the long-standing position of the courts and the policy of the law not to allow a contract breaker to derive advantages from breaking his contract. And there is a succinct and very well known passage dealing with that policy in Alcassane, in Lord Jauncey's judgment, which is at tab 14. And the relevant passage is in the red numbering of the authorities bundle, page 198 to 201. In this case, the buyers derived two, we say, substantial advantages from putting a stick in the spokes of the deposit holding machinery. The first of those was that they deprived us of, or at least ambiguated, our ability to terminate for non-payment of the deposit. For as long as they were able to say, and they continue to say, oh, we weren't liable for the deposit, we couldn't exercise our right under clause 13 to terminate and forfeit. And for them to be able to, over several weeks, take the benefit of the continued performance of the contract, the ships were still sailing to the delivery point, without actually having to put their money where their mouth was a substantial benefit. The second is that if they're right that unless the abacha principle applies to this case, they will have succeeded by not supplying the necessary copies of their passports in down-rating the jeopardy they were in from that of a deposit provider who is at risk of losing his deposit and being liable in damages to someone who is merely liable in damages. So they say and this is Mr. Eaton's completely frank about this. He says, because we didn't hand over copies of our passport, we never put our 4.5 million deposit at jeopardy of being forfeited. It's up to sellers to recover what they can in damages, subject, of course, to causation, remoteness, and in this case, the application of our argument about the golden victory. So those are two very substantial advantages. Effective protection from cancellation under clause 13, not having to put themselves at risk of forfeiting the deposit, which they say they can get as a result of, direct result of, not complying with their obligation to provide copies of their passports or whatever the KYC documents were. That's what we say about the principle and justice. It's a principle they shouldn't be allowed to get advantages from their breach. They manifestly are. Finally, I just want to pick up a couple of important points about the general principles that bear on this question. And you will have seen the classic way. We started our skeleton with the authorities and then moved on to general principles. Mr. Eaton started with general principles and then at the end came on to authorities. I want to look at Mr. Eaton's general principles of justice, which obviously substantially influenced the judge. And he identified 9, but I just want to take a couple of them together. So I won't. I'll look at them under 5 heads. All right. The first is, he says, the Abacha claim, or the Abacha principle, it is giving the sellers, applying the Abacha principle, is giving the sellers a claim in debt as a remedy. And a claim in debt's not a remedy. You're confusing primary obligations with remedies. And our answer to that is an answer that I tried to spell out in opening this, that you must avoid collapsing step 1 and step 2. We don't say that the Abacha principle gives us a remedy of a claim in debt. What the Abacha principle does is hold that they were liable to pay HFW the deposit as a deposit and precludes them from claiming that the absence of confirmation from HFW that the account was open has the effect that the obligation didn't fall due. Once you accept that, and it's a conclusion about the nature of their obligations under the contract. It's not a remedial decision. It's a conclusion that they were under a contractual obligation to pay HFW. Once you conclude that, then what follows is that you, or as it was the tribunal, accept that we were entitled to treat their failure to pay the deposit as a circumstance justifying the exercise of our right to terminate under clause 13.
Well, I understand that on the facts of this case, but if the question were being asked in the more general form that it was formulated for the purposes of the Section 69 question of law, so that one were looking at the issue by reference to a case in which the obligation was not to pay a third party, but the obligation to pay the debtor directly. Then that point wouldn't arise, but well, the same objection would be being made.
I of course I accept that, and there may be in another case, in the Panamina, for example, it may be said, well, there's a rather more direct transition from the application of the abatia principle to the claim and debt. But nevertheless, the same point is made. The effect of the Panamina is just to, in the first place, recognize that the obligation to pay has come into existence. It's not a remedial decision, it's a decision about what the primary obligations are at a particular point in time.
That's on the facts of this case, but if...
No, in the Panamina is what I've meant.
Yes,
Yeah.
because that was also a third-party certification case.
Yeah.
But if the precondition to the debt obligation is a precondition to the debt being owed directly by the counterparty, and the condition relates to something the debtor has to do, not a third party has to do, I think Mr. Eaton would still make the same objection that you were in those circumstances, to which you say the abatia principle would equally apply, creating a remedy of debt.
Well, maybe in those slightly different circumstances, the two positions, it's hard to push a piece of paper between them, but I mean, I would stick to my guns and say it's what it's recognizing is the existence of a primary obligation rather than giving rise to some remedial obligation or secondary obligation. Okay,
You say that the primary obligation is to pay money.
Yeah.
Doesn't matter whether it's to pay money to me or pay money to someone else. I get the normal remedies I would get if you don't pay the money.
Exactly.
And on the facts of this case, that means I can terminate the contract and then sue you for a deposit. But that's just how this contract works. As a matter of principle, what you're getting is...
All you're doing is, as it were, as you rightly put it earlier, debarring them from relying on something to defeat the existence of the primary obligation. Okay, the second point is the causation point, and Mr. Eaton's point, and it's a point that obviously chimed with the judge because she looked at and referred to the relevant textbooks, was the abatia principle overrides causation. Right, and the way Mr. Eaton puts it in his skeleton at paragraph 35 is that the abatia principle assumes that if the debtor had performed its primary obligation, nothing would have intervened to prevent the satisfaction of the precondition. So maybe helpful just to have that. Paragraph 35 is this skeleton. Just below the reference to Holson and Chitty, the abatia principle effectively assumes that if D had performed its primary obligation, nothing would have intervened to prevent full satisfaction of the precondition and or the earning of the debt. We just say that's not right. The way the tribunal formulated it was it had to be shown that the breach had prevented the satisfaction of the condition. And they actually decided an issue as to causation because the buyer's case in front of the tribunal was, well, our default didn't cause anything because you were in default. Right? It would have happened anyway. Now, we therefore say that's just not right as a observation about the way in which the tribunal formulated the principle, not right about the way in which the principle was applied in this case. Causation is, and I just I'll take you to abatia now. Causation is touched on in abatia, where Lord Justice Ricks says that the breach must be causatively relevant. Right? In other words, the breach by the debtor must be relevant, causatively relevant to the non-fulfillment of the relevant precondition. And that's paragraph 106, page 368. And then it says again at 120, at paragraph 121, that's page 372. Right, 372, top of the page, sub 1. The relevant wording is, the S.J. Bowen defendants cannot assert the non-fulfillment of that condition, that's the precondition to bear liability to pay, which their own wrongful breach of their obligation of cooperation has prevented from being fulfilled. So again, Lord Justice Ricks is recognising that it's not enough merely that you've got a breach which has the effect that the precondition is not satisfied. It's actually got to have legally caused the non-satisfaction of the precondition. And that then is the answer to the passages in Chitty and in Tritle, which obviously troubled the judge. The two passages in question are at, first of all, in the main authorities bundle at 581. This is from Tritle's Law of Contract, as now edited by Edwin Peel. And the relevant bit says, and these are the bottom of the red-lined paragraph, to hold that the party in breach liable for full performance promised by him on the fiction that the condition had occurred seems to introduce into this branch of the law a punitive element that is inappropriate to contractual action, 580. More recent authorities hold that such doctrine of fictional fulfillment does not form part of English law. Now, that would be right if, just to take the facts of Mackay and Dick, all that if it was to be said that all the seller has to prove, the seller's right to payment is subject to the precondition that there's been a successful test. And if it were to be said that all the seller has to prove was that the buyer in breach of contract has prevented there being a test, and it's then going to be assumed not only that there has been a test, but that it's been successful, that would be punitive in exactly the way that Mr. Peel is here saying. You would say, well, hang on, that's removed any requirement on the seller to demonstrate that this test would have been successful. That's not how we put it, and not how we need to put it. It's in our submission, the true test is whether, in circumstances where the buyer has prevented a test of the machine, whether the seller can prove that if there had been no breach of contract, the test that would have been carried out would have been successful.
But that wasn't what was done in Mackay and Dick.
In Mackay and Dick, there was no pleaded issue that the test, if it had been carried out, would have been failed. It was argued that if the test had been carried out, it would have failed. But the whole business of the analysis of the pleadings was to demonstrate that, in fact, there was no pleaded issue about the ability of the machine to perform the test.
But that's not the way in which the House Lords deal with it. They don't say if only this had been pleaded correctly, you could have got this issue off the ground. What they say is that by not providing the ability for the test to take place, you've given up your ability to rely on the test at all, don't they?
With great respect, no.
No. Okay.
Let's just
You did say you wanted to deal with Mackay and Dick in reply. But
Yeah, I did. But let me just quickly say that I throw down the gauntlet for Mr. Eaton. He's about to pick it up. Show you that. In Lord Blackburn's speech, we pick it up in at tab 5 of the main authority bundle at 67. And the critical wording is
So I was just making a note. Which page are we at?
so page 67, the main bundle, so that's tab 5. The much
you.
glossed wording at the bottom of this first paragraph, it would follow in point of law that the defender, having had the machine delivered to him, was, by his contract, in other words, the effect of the contract was to keep it, unless, on a fair test, according to the contract, it failed to do the stipulated quantity of work, in which case he'd be entitled to call on the pursuers to remove it. By his own default, he can now never be in a position to call upon the pursuers to take back the machine. Now that's not, that doesn't involve whether the test would have been successful or not, because the way he's construing the contract, he just says, you've got to pay for it, keep it and pay for it, unless you have a test and then can demonstrate that the test was unsuccessful. So on his question, there's no assuming the test would have been successful, which introduces the jeopardy that Edwin Peel is referring to. But he says that, but then he goes on to say, over the page at 68, was, however, argued at your lordship's bar that there was another ground of defence appearing on the evidence, and that was, see the next paragraph, that the machine was so bad that it couldn't possibly in substance have satisfied the contract. And then he talks about the legal effects of that, in which he's already given a judgment. But the disposal of that point starts at the bottom of the page. I agree that if such a defence had been raised on the record in this case, the Court of Session ought, in their interlocutor, that is the order, to have found out how much, if any, of the allegations were proved in fact. But it's because having read the record and having the advantage of Lord Watson's observations on the record, I'm clearly of the opinion that no such defence was raised by the issue.
Yeah.
All right, and then 68, then looking at Watson's judgment, he starts with a long analysis of the pleadings, right? But we get to the conclusion on the pleadings at page 72, around the second whole page. Where Lord Watson says, taking all his averments together, right? So this is the sum up of the his analysis of the buyer's pleadings. They appear to me to disclose no ground of defence to the action except one, that the machine was disconformed to contract, as was evidenced by the fact that it had been subjected to the contract test by working at a suitable face and had failed to perform the stipulated amount of work. In other words, his pleaded case was, we did do the contract test and it failed. And it's a notable circumstance. This, and then he says, this view of the appellant's record is borne out by his pleas of law, the only pleas which indicate any substantive defence to the respondent's claim for the contract price of these, the machine having failed on trial, in other words, on the agreed test, the defender is not bound to accept it. The sale of the machine being conditional on the trial, which has failed, the defender is not liable. So his pleaded case was, we did do the contract test, and it failed. And then Lord Watson goes on to say, in order to make that good, he has to actually prove that there was a contract test, and he hasn't done that. He says the respondents were, the terms of the contract seems to me to imply very plainly that it was incumbent on the appellant and not the respondents to provide a properly opened up face for the machine. So again, there wasn't a the summary that one makes of this is that he reviews the pleadings, and there is not a plea that even if a contractual test was not carried out, the machine was so bad that it would have failed that contractual test. The only plea is that there was a contractual test, and that plea failed. So, again, I enter into this whole territory of what Edwin Peel says about punitive at my risk, because it doesn't arise in our case. But I simply say that insofar as it's relied upon by the buyers as being a defect in the abacha principle, that somehow it assumes, once breach is proven, that the breach would have caused, or that the breach did cause the precondition not to be fulfilled. Right? As soon as it's proven, to take the simple example of Mackay and Dick, as soon as it's proven that there was a breach in holding a test, that somehow it can be assumed that the test, if it had been conducted, would have been a successful test. That is not supported by the authorities. That is something that is not only not supported by the authorities, it's not supported by the test that the tribunal applied in this case. The version of the abacha principle that we invite you to say was correctly applied by the tribunal is one which requires the party invoking it to prove, which is what we did, that the breach by the debtor caused the precondition not to be satisfied. It has that causal element to it.
But irrespective of the pleading points, is that causative link not established on Lord Watson's principle? The condition precedent to the right to the price was a successful test at Carfin on an open face. The reasoning is that by not providing an open face, they prevented that condition being fulfilled. Because a test couldn't take place. Ergo, entitled to the price. They've prevented a successful test taking place by preventing any test taking place. How in that analysis would the question arise as to whether, if the test had taken place, it would or wouldn't have been successful in the contractual terms arise?
Well, if you apply the principle broadly, the answer is it wouldn't have to. But if you apply it in the way in which this tribunal applied it, it would have been open to the buyer to say, I admit my breach in not providing a properly opened up face, but if I had done that, the machine was so hopeless that the test would have been completely unsuccessful, and therefore it's not to be assumed against me that the test, if I'd made it available, would have been successful.
The breach would still have been causative of the condition not being fulfilled, wouldn't it? Which is, you say, all that you need to establish for the Abacha principle to apply. The breach in that case caused the test not to take place, and that's what caused it not to be fulfilled.
On one view, but another view is in circumstances when the machine could never have passed, it didn't cause the failure to conduct a successful test. Successful test could never have been carried out. It's my lord, there's.
Could you just pause for a moment while I make a note of that? Thank you. Thank you.
I was only going to add that there's another line of authority that's closely related, which is the Armory and Delamere line of authority, or contra spoliatur omnia praesunt, where a party who prevents there being evidence of a matter is exposed to the court drawing inferences against him. So one could well see that it may be said, well, I didn't allow you to conduct a test on my opened up face. It's to be presumed against me that if I had allowed the seller to conduct a proper test, all presumption should be made against me that if I'd allowed a proper test to be taken place, that the test would have been successful. But that's a separate principle. Here, it's sufficient. You can narrowly apply Mackay and Dick by saying, and that's how the tribunal did it in this case, by saying, no, it's up to the person invoking the principle to show that but for the breach by the putative debtor, the precondition to the debt would have been fulfilled.
You're expressing it there as but for, but I think you were referring earlier to sort of legal effective causation.
And I'm only trying to tease out one element of legal causation. I mean, it's generally, at least very often said, that but for is a minimum before legal causation can be. So in the present case, it would have, just coming back to the facts of the present case, it would have been open to the buyers to prove that their breach in supplying documents was not a but-for cause, not a legal cause, not a cause of Holman Fenwick's failing to confirm that the account was open. Because they might have said, well, you know what, Holman Fenwick had decided to stop being a deposit holder, or you know what, you failed to provide the documents too.
Well, you'd have two concurrent causes, wouldn't you? I mean, we may be going down a rabbit hole slightly,
Yeah, we may be.
You'd be looking at two concurrent,
Anyway,
on the assumption that neither side provided the necessary know your client documents. Say that's the factual hypothesis.
Yeah.
You would have two concurrent
We
causes
would-
of
we-
the
we would say this-
inability for Holman Fenwick and William to open the account and declare that it was ready to receive funds.
we simply say that I just
But you
come
say
back.
causation in those circumstances wouldn't be established.
I come back to the answer is yes, and I come back to and that was indeed their case in front of the arbitrators, that it wasn't caused, that the failure to satisfy the condition wasn't caused by them, because it would have happened anyway, because we had failed to provide the documents. So I simply come back to the point, insofar as it said this is punitive because it involves an artificial assumption about what would have happened, the answer is no, it doesn't. Not as formulated by the tribunal here. They've simply asked the question, has the breach by the debtor prevented the fulfilment of the precondition?
But
And that's a causative question.
Oh, yes, but are we then teasing out that actually the principle is it the sole cause?
No,
Is it the debtor's breach which is the sole cause
it's
of the condition not being fulfilled?
it's an effective cause.
An effective
An
cause.
effective cause, a legally effective cause. And then I
Well,
accept,
an effective cause would be one of two equally efficient causes,
yes, and I accept that.
and
But
then in which case the tribunal wasn't applying that causation test in considering whether the owners themselves, that the sellers themselves were in breach in failing to provide relevant documentation.
I will leave it on this basis, that it would be wrong to assume that the application of the Abacha principle requires any artificial assumption to be made about the cause of the non-fulfillment of the relevant condition. The way the tribunal in this case applied it was on the basis that it had to be established the breach had prevented Holman Fenwick from giving the confirmation. There is nothing either artificial or punitive about that.
Well, the punitive point is slightly wider than this question of causation, because it encompasses a whole raft of points about the normal measure for breach of contract is compensatory, and that brings in all sorts of rules about remoteness of damage and mitigation and the like. And you don't have that with a debt, which is a slightly different point.
That's one of Mr. points. Another of them is that the application of the Abacha principle involves discounting the possibility that had there been no breach, the precondition might not have been satisfied anyway.
Yes.
Right? That's the point that Edwin Peel makes. That's the point that is made in Chitty. Those were the two extracts that the judge referred to. Let me just give you the references. It's Chitty, paragraph 4.205, and at page 581 of the authorities bundle. and Tritle paragraph 2.112 at page 451.
I think those two references are the wrong way around.
Sorry if I...
Yes.
So those are the two references. Both of them are advancing the proposition that there is a punitive element to the abacha principle because it assumes or discounts the possibility that even absent even if there had been no breach, the precondition would not have been satisfied. And we say that is not a necessary part of applying the doctrine.
Who is the editor of this part of Chitty? Is it also Professor Peel? Because the wording seems identical.
Both passages were written by Tritle.
Right.
And the current editors of the two books, one is Edwin Peel, the other is Chin Wishart.
Yes, but both of them have left Professor Tritle's words untouched. Yes, I see. Thank you.
All right. The final point that I wanted to address on the justice and principle nature of the abacha principle is the contention that's Mr. Eaton's fourth and fifth point, which is that it involves sellers getting the price without having to deliver the goods, or service providers having a claim for the price of the service without having to perform. And that is a point that has been, we've discussed already, and which I don't tend to repeat what I've said earlier. There is obviously a limitation on the principle which is expressed in Colley, namely that a seller can't recover on the Mackay and Dick abacha principle without delivering the goods. And that can be explained either on the basis of Newmont, that is, the application of the principle depends on the terms of the contract, or it can be explained in terms, as we suggested in our skeleton, that the party relying on abacha must show that he has done everything to earn the debt, in other words, everything that he can do. But either way, the existence of that limitation doesn't cast any doubt on the application of the principle and the facts of this case, which are indistinguishable from the decisions that we've looked at.
Doing everything he can do explanation doesn't really work in Colley, does it? Because the seller had provided the goods, and if only there'd been a ship, he would have put them on board, and there was no ship.
Yeah, let's go back to your pleaded case. He would have to plead for the price that he had delivered them. And if he hadn't, it may have been that he was prevented from doing that.
I see.
Well, that's a slightly different formulation from doing everything he can do to earn the debt.
Everything
the seller has done
not
in that
everything he
case.
can do, everything he has to do. He's got to have provided the performance that is required of him in order for the debt to accrue.
That might be a solution to my lord's concurrent cause problem. If you'd failed to provide KYC, you couldn't rely on the abacha principle on this basis. And you wouldn't have to answer, does it apply if there are two concurrent causes? Because you don't bring yourself within you don't get home.
Yeah, I mean, I accept it could be expressed either in those terms or in terms of causation.
Yes, but they might have different results. Yeah, but I can see. Yeah.
And Lords, my lady, that's everything we wanted to say at this stage.
Thank you. Yes, Mr. Eaton.
My lords, my ladies, since we have Mackay and Dick open, can I just say something briefly to begin about this causation? Lord Blackburn in Mackay and Dick, as we said on last occasion, he doesn't approach this from the perspective of condition precedent at all. He approaches it from the perspective of condition. The condition precedent analysis is Lord Watson adopting Bell's principles, and that's what's really picked up by Lord Justice Riggs and Thatcher. That's the deemed fulfilment, which is sort of the heart of the proposed principle. And it's quite clear from what Lord Watson says at page 73. That what is deemed fulfilled is the totality of the condition present, not part of the condition precedent, and then everything else is a matter of factual causation which can be inquired at trial. He says that the condition of the right to receive payment was that it should be tried at a proper working phase provided by the account, and that on trial it should excavate a certain amount of play. There are two aspects to it. There's got to be a trial, and it's got to be a trial that passes a threshold. They have been thwarted in the attempt to fulfil that condition. Again, it's referring to the whole thing. And then on the basis of Bell's principle, they must be taken to have fulfilled the condition. It's the whole thing. What is deemed is that there has been a test and it's been passed, and therefore the money is earned. There is no hint or shred of suggestion in Bell's principles or in Lord Watson's speech that the correct analysis is that what is deemed to happen is a test. And then you have an argument on the facts about whether the deemed test would have been passed or not. Which is rather peculiar. Why deem the test to have happened at all? Why don't you just say, well, it's a question of whether the test would have passed if there'd been one? The deeming becomes redundant. So it's the whole, it's the totality of the condition which is deemed to have been fulfilled. And the whole question of whether or not the test, if it had been performed, would have been passed, is totally out of account, because it is simply deemed that it would have succeeded. That's precisely why, although they loyally applied Bell's principles, as did Lord Watson, their lordships in the Court of Session were unhappy to do so. And your lordship and your ladyship will see that at page 49, where we have the judgment of the Court of Session. And at the top of page 49 of the whole punch, this is the leading judgment of Lord Sham. And he says it follows that the Scottish language for the claimant wins. And he says, I say unfortunately, but that decision does not turn upon the merits of the machine with full evidence to enable the court to say whether it was fit to execute the amount of work in a given time. It would have been more satisfactory to me if we'd been able to decide upon it. But the deeming fulfilment just renders the whole of that out of court. And Lord Dees entirely agrees with that observation. And Lord Muir comes to the same conclusion. The Lord President concurs. And similarly here, it's really just taken for granted that if we had complied with the promissory condition and provided the documents to HFW, then HFW would have opened the account and confirmed it, and the debt, the deposit would have been lodgeable. My learned friend appears to imply that paragraph 21 of the award, page 81 of the bundle, is some kind of finding of fact on causation, that if we had provided the documents, Holman, Fenwick and Willan would have opened the account as a matter of fact. Not that, it's just a finding that we were in breach and the sellers weren't. That's all that's decided there. That it would have followed as night follows day that the account would have been opened if we had provided the documents is just taken for granted. It's a point which Her Ladyship made in the judgment at paragraph 120. So it's possible that Holman, Fenwick and Willan wouldn't have been able to open the account for some reason, even if we provided the KYC document. Now, the deeming just assumes it would have been done, and that was a point which Her Ladyship raised, and it's probably on the facts, not very likely. I don't know if we.
Well, realistically, unless the tribunal were faced with a an argument which suggested
I take the Lordship's point.
a ground for that to be the
I
case.
take the Lordship's point, and I don't think we did raise one below. But the point that her Ladyship made is, if you're looking at an orthodox claim for damages, then that sort of thing can be taken into account.
Well, I think Mr. Kenny's argument is if that does arise, then there will be a causation question which the fact finder will have to determine.
On a claim for damages. It will be taken into account.
No, he says on a claim applying the abature principle.
But my lords, as we just see from that's not Lord Watson's approach. You deem the totality of the condition, or simply deemed fulfilled.
And in Mackay and Dick, what was the purpose of the quite lengthy consideration of what was described as the pleading point, i.e. the statement of the record in the Court of Session from the Sheriff's Court? And why did that arise at all?
It arises, my lord, because the broad point which arose under the Administrative Justice Act, as I believe it was, that by the time you got to the House of Lords, it was only open to review questions of law and not questions of fact.
Yeah.
And at some point, I'll try and find it, an argument is raised about whether points which are being run before the House of Lords are questions of law or questions of fact. Let me see. Well, we'll see. It arose first at page 259. At the top of page 259, one sees that at some stage in the proceedings, a petition was lodged arguing that the entire appeal was incompetent because it was an attempt to appeal questions of fact. At the bar, that petition was abandoned. So at a very late stage, the argument that the Lords simply could not hear the appeal under the Act was abandoned. But then below, some point about the fact is still being raised lower down on 259. The interlocutor of the court contained no finding as to whether or not the machine could afford the contract. As to other matters of fact raised on these grounds, they asked the case be remitted to the court below to now finding matters of fact. And the broad answer to your lordship's question, without being able to go into the nitty-gritty of Scottish Victorian procedure, was that the Lords looked at the Acts and the interlocutor of the pleading to decide whether they should send it back for any further findings of fact on any point at all. And they ultimately decided no.
But what that supposes that there would have been issues of fact which were material to the conclusion that Lord Watson drew about deemed fulfilment.
Or might have been, depending upon what the principle of law was. But the principle of law as stated by Lord Watson, those points of fact, they wouldn't be relevant anyway.
But it's a bit odd then that he spends several pages addressing the question of whether it would be opened for those to be considered.
I see that, my lord, but that's in a context where right up until the last minute they were faced with a petition saying that they should just dismiss the appeal in limine the question of fact. And then even after that had been abandoned, there was an argument put to them that they should send it back for questions of fact. And what I would suggest is that they were considering the point of principle and in what circumstances would it be appropriate for the House of Lords to remit a case to the Court of Session for further finding of fact. They give some guidance on that, they give some guidance on the meaning of the Act. But in terms of Lord Watson's proposition of law, those matters as to whether or not the machine would have passed the test could not affect the outcome, because on Lord Watson's proposition of law, the requirement for the test in toto is deemed satisfied, including that it would have passed.
Was Lord Watson's reasoning part of the ratio of the case?
My lord, yes. There are two ratios in the case because there are two judgment speeches, and the Earl of Selborne agrees very briefly with both of them.
Even though they're mutually inconsistent in this respect?
They may not ultimately be mutually inconsistent, which is the point I will come to. They are they start from a different starting point in the sense that Lord Blackburn says this is all about conditions defeasant, and Lord Watson says it's all about conditions present.
Quite.
But on the view which has been taken in the subsequent cases, which is, to tell you briefly, that property had passed and therefore the price had accrued due. on that view, it doesn't matter whether it's a condition precedent or a condition subdefeasant. And that may explain why Lord Selborne found it very easy indeed to agree with both, although they took different points of departure. My lords, my lady, this is a somewhat scrappy area of the law. As perhaps the discussion which we just had about why their lordships and the current going on about the Administration of Justice Act perhaps illustrates. It's an area of law where the court is asked to try and ascertain what is going on in an old case like Hotham and East India, which on the face of it is a discussion more about Georgian pleading than any substantive point of law. It is also, if I may put it politely, it's an area of law which is punctuated by a certain looseness of judicial expression, in the sense of statements being made which are broader than their context requires, and statements which may be apt to mislead if they are approached as being abstract propositions of law, and one attempts to apply them in different contexts. And a good example of that is the principle, much prayed in aid by my friend, that a party may not be permitted to derive a benefit from its own breach of contract. That's a proposition which, if taken literally and applied in all circumstances, would have very far-reaching consequences for English law. In fact, as Lord Diplock put it in the Cheel case, it is quote-unquote broad language, but what is really quite a specific principle of the construction of contracts. The principle is that as a matter of construction, it will be presumed that a party is not entitled to rely upon a termination clause in the contract if the event which gives rise to termination has been brought about by that party's own breach. Now, when compares that actual principle with the maxim, party is not entitled to derive a benefit from its own breach of contract, one can see that the underlying principle is in fact much narrower than that. In the Albu-Hyston case, it gets broadened out beyond termination clauses to other clauses conferring a benefit. But the principle remains still, basically, that as a matter of construction, it's assumed that a party cannot rely upon a contractual clause which confers a benefit if the condition which triggers it has been brought about by the party's own breach. As Lord Diplock says in Cheel, it's often broadly mentioned by that maxim. The party may not derive a benefit from its own breach, but that maxim is apt to mislead if you don't understand what it is really talking about. And in my position, it is true in a number of the cases that some fairly broad sweeping propositions have been made, which make sense if you examine the context. If you take those propositions away from the context and try to apply them in different circumstances, you will be misapplying what has been spoken about. Now, before I get into the detail, I was going to submit that by way of broad overview, the true state of the law in this area is reflected in a number of passages in the House of Lords in Luxor and Cooper. That is tab 48 of the authorities bundle, beginning at 637. Now, this is the familiar case in which a cinema owner agreed with an estate agent that if the agent introduced willing buyers, the owner would pay a fee of £10,000 on completion of the sale, which, as Lord Russell rather acidly commented, was equivalent to the Lord Chancellor's annual pay at that time. And the agent found a willing buyer, but the owner decided not to sell. And so the agent sued. And a key point to note, and it's apparent in the head notes at 637, is that the claim was brought not indeed to the Commission as such, because the sale never took place, but the damages of the same amount because he would have earned if the defendant had not broken an implied term. So it's not a claim that's put in debt, because the agent concedes that the conditional precedent to the accrual of the right in debt has not in fact occurred, and therefore it has no claim in debt, so it sues in damages instead. And the issue before the House of Lords was whether there was any relevant implied term which the owner had broken to support the cause of action in breach of contract. And one sees in the head notes that the answer was that there was no relevant implied term, and therefore there was no breach. So it's right to say at the outset, to recognise at the outset, that the House of Lords in Luxon Cooper was not asked in terms to decide whether a debt would have become unconditional if it's expressed is subject to conditional precedent, but the condition is not satisfied through debtor's breach. That's to say, they're not asked to decide, well, would there be a claim in debt if the owner had been in breach. But nevertheless, the passages I'm about to show the court, I submit, show that the Lords took it as effectively axiomatic that unless the condition precedent was fulfilled, there was not a claim in debt, whether there was a breach or whether there wasn't a breach. Because if the condition wasn't fulfilled, it wasn't fulfilled, and if it wasn't fulfilled, the debt did not arise. Now, the first passage is 643, right at the bottom. This is Viscount Simon.
Could you give me the internal page numbers, please, because I've got it
Yes,
separately.
brother. 114.
Thank you.
There's a passage that begins right at the bottom, it seems to me. He then sets out the express bargain. No such sale, however, took place. Accordingly, there could be nothing due corresponding on the terms of the express bargain. Then it goes into the case that's put on an implied term. And your lordship will just note that he doesn't say if the agent writes that they're in breach of an implied term, then that changes things. It will be decided in debt. He says there's no claim in debt, and then he just goes on to look at it as a matter of damages. Lord Russell at 652 of the bundle, 123 of the internal numbers. Very close to the bottom, upon the oral evidence, the only contract he sets out what he believes the contract was, that's the only contract Crude. The question is what the liability was. And then over the page at 653, the only right of the plaintiff was to receive his commission out of the purchase money even when received. His right was a purely contingent right. The contingency was not satisfied because there was no completion. And he too goes on to claim for damages. At 658 is the bundle, 129 of the internal numbering. Just right at the bottom of Lord Russell's speech, he says that Lord Thankerton has agreed with him. And I just ask the court to note that, bearing in mind that Lord Thankerton gives the leading speech in Panamina, on which the sellers rely. At 665 of the bundle, 136 of the internal, Lord Wright About 2/3 of the way down the page, it's long been held that at least prima facie the right accrues and the obligation to pay attaches to the principal. I think that's the correct construction. That condition was never fulfilled. And then at 681 of the bundle, 152 of the internal, Lord Roma, at the bottom of the first paragraph, about more than halfway down, he sets out his understanding of what the contract was. And then in the next paragraph, the sale never materialised, the agreed commission never became payable. And then it goes on to the claim in damages. And then if you go back to Lord Russell, the thing before Lord Tankerton agreed, at page 657, of the bundle numbering 128 of the internal numbering. It says right at the bottom, the legal position can be stated thus. If, according to the true construction of the contract, the event has happened upon the happening of which the agent acquired a vested right to petition, by which I mean it is debitum in praesenti, even though only solvendum in funturo, then no act or omission by the principal or anyone else can deprive the agent of that right. But until that event has happened, the agent cannot complain if the principal is needed to proceed. And I submit to the court that those passages reflect two propositions which represent the law. The first, which is reflected in all of the speeches in the first set of passages I showed the court, is that if the accrual of a right in debt, the vesting, as Lord Russell and Lord Wright both say, or the earning, as one might say, if the accrual is subject to a condition precedent, then the debt does not accrue unless and until the condition precedent is satisfied. Agent in Luxor had not earned commission as a debt, there was no accrued commission because there had not been a completion and the condition precedent had not been satisfied. And that first proposition, I submit, it follows from ordinary principles of construction and ordinary rules of freedom of contract. If the parties have agreed that a debt will not accrue, will not vest, unless and until a condition precedent is satisfied, then the contract will be construed as meaning what it says, and it will be given effect according to what it means. To say that if the condition is satisfied, the debt accrues, but if the condition is not satisfied by reason the debt is breached, the debt accrues anyway, is in effect to just ignore the condition, to write it out of the contract. And that does not give effect to the contract according to its meaning, or according to the terms which the parties agree. Of course, if the reason the condition precedent is not satisfied is due to a breach by the debtor, then the creditor will have a claim for damages in the usual way, and that was the claim that was put in Luxor and Cooper. But that will be a claim for compensation to be assessed according to the usual principles of causation, remoteness, mitigation, loss of a chance, and so forth and so on. It will not be a liquidated claim for the enforcement in specie of a primary liability in debt. The second proposition which I submit is reflected in these passages is reflected by the passage from Lord Russell about once the right is vested, no act or omission by the defendant will take it away. And that also, in my submission, follows from ordinary principles. Once a party has acquired a vested debt, or indeed any other vested right, there will usually be no principal basis by which subsequent events can deprive it of that right. And for example, the commonplace rules that neither termination for breach nor automatic termination by frustration will affect accrued rights. In principle, an accrued right under a contract will only be divested if the contract is avoided ab initio. But subject to cases such as fraud or duress, there's no unilateral power to avoid a contract ab initio and thereby avoid an accrued debt. And that distinction between a debt, it's not really accurate to call it a debt, but for ease of reference is what I'm going to do. That distinction between a debt which doesn't even accrue unless and until the condition precedent is satisfied, and a debt which has accrued and is debitum in praesenti solvendum only in futuro on satisfaction of a condition precedent payment. That distinction was recognised by the judge, and it's a distinction which runs through the judgment and the judge's treatment of the cases. And in my submission, the judge was quite right to recognise that distinction and to recognise that it is a key to understanding some of the cases on which the sellers rely on this appeal. Now, in their arguments before the tribunal, the sellers recognised that distinction themselves, and indeed they relied upon it. But on this appeal, they say that there is no such distinction at all as a matter of principle. And the court's reference that's in their skeleton arguments, tab 8 of the bundle, paragraph 25, 36, and 77. I've just noticed it in those situations at all. And in my submission, as my Lord Justice Popplewell was indicating, it's a real significant distinction. If a debt has accrued, the creditor has a vested right, and because it's vested, it can be relied upon as a set-off, or it can be attached by way of a third-party debt order, which was the whole issue in the Dunlop and Hendel case that my learned friend took you to. It can be assigned. It will have a liquidated value because it's a debt. If the debtor, when the debt becomes due, breaks the contract and doesn't pay it, it can be recovered in specie in the liquidated amount as a debt by an action in debt. It's not a claim for damages, and damages rules don't apply. By contrast, if the debt has not even accrued, there is no asset in existence which can be attached or set off. There is merely an expectation that the debt may accrue in the future if the condition precedent to its accrual is satisfied.
Well, I ought to know this, but I don't. What's the position in insolvency? It's an accrued debt provable in insolvency if it's not become payable.
I believe, my lord, this is trespassing out of my area, I'm afraid, but on a quick look on Durham on set-off, I believe that an accrued debt which is not yet payable can be set off. But a debt which hasn't even accrued, as I understand it, cannot, because it's not a debt.
Yeah, but can it be proved for in insolvency at all?
I'm not sure that's right.
I'm not sure he's my lord either. As I say, it's getting out of my area.
I think contingent debts and other debts, and indeed other claims, can be proved for.
It's possible with a claim for damages, as I understand it, to make some sort of proof.
It's for the liquidators to value contingent debts.
It's a question of, maybe a question of valuation.
Debts of all types, whether vested or contingent, I think can be proved for, but I mean, that's my understanding, but I may be wrong.
Thank you.
But one can see, I suppose, looking at it that way, that if you have an accrued debt subject to a contingency, and you may have to give a discount for the contingency, then at least you're starting with the value of the liquidated value of the debt as your starting point. Whereas if you've merely got an expectation claim, a claim for damages or something, then you've got to jump through all the hoops of valuation in terms of causation, mitigation, loss of a chance to work out what the value of the damages claim is, as it were, from the bottom up. So it's going to be an easier exercise when you've got an accrued debt than when you've got a mere expectation. But the expectation doesn't have any sort of liquidated value at all, simply because it may never accrue to you. And if the expectation is defeated by the breach of the other party, the remedy is not enforcement in specie of a liquidated sum, it's damages for loss of expectation. And it's expectation damages, that's why they're called expectation damages, with all of the usual principles coming into account, and based on the compensation principle of net loss, rather than on any liquidated sum. So there is, in my submission, differences between an accrued right in debt and expectation, very obviously. There's also, perhaps this point, that once a right has vested, and this again harks back to Lord Russell's comment, once a right has vested, then it's up to anybody who contends that you have somehow lost that right to justify that claim and explain why and how it has happened. And it isn't easy to do, because again, on normal principles, accrued rights are not lost by termination or breach or by frustration or any other prospective termination of the contract. They're only lost if you set aside the transaction ab initio. And that being the case, it's entirely natural, in my submission, that the law takes the view that failure in the machinery for payment of an accrued debt does not have the effect that the debt is effectively extinguished and never ever becomes payable. Obviously, used in cases like the Karen Vattis. Now, on the other hand, if the debt is not vested, if it's not yet accrued, then the onus is firmly on the creditor or prospective creditor to show how and when it has vested. And again, on normal principles of contractual construction and freedom of contract, that will not happen unless and until conditions precedent which the parties themselves have specified in the contract have been satisfied. Now, I would make three other points about Luxor. The first is that is a case in which, on any view, the agent had done all that it could and all that it had to earn the commission. Its job was to find a willing purchaser, and it had done. The outstanding condition, which was the completion of the sale, was entirely a matter for the vendor. It was something to which the agent had no contribution to make. I do highlight that point because, as the court's aware, my learned friend seeks to explain cases like Colley by saying, oh, well, you can't rely upon the abacha principle unless you've done all that you have to do. The agent in Luxor had done that. But that doesn't lead to any suggestion in Luxor that if they can establish a breach, they can recover the debt as a debt. They don't even argue.
That's because there was no breach of obligation.
Well, they were arguing there was a breach of obligation, my lord.
Yes, and they failed.
Yeah, and they failed, but they did. But the only case they put was if there's a breach of obligation, we're entitled to damages. If my learned friend is right, then if they could show the breach of obligation, then they'd have a debt claim. Because the reason that the condition precedent of completion didn't take place would have been that there'd been a breach by the vendor in failing to complete. So it's on the pleaded facts. The case is slam dunk within this general principle, which is put by my learned friend. It'd be an open and shut case. There'd be no answer to it. They'd done absolutely all they were expected to do. They'd done all they could do. The only reason they didn't earn their commission was by a breach by the vendor in failing to sell. It's true, it wouldn't have worked because there wasn't a breach, but even so. It wasn't argued, although they were saying there is a breach. They didn't even think to argue that means that we can claim in debt. They took it as axiomatic that their only remedy for breach was damages. And the passages which I showed the court showed that so did all of them. No one thought, oh well, if this breach of contract claim gets off the ground, that changes the landscape. Because we'll be able to say, well, the only reason why the condition precedent wasn't fulfilled was the breach. So we'll deem it fulfilled, or say that it's waived, or some other principle, and it'll be a straightforward claim in debt. It just doesn't occur to anybody. Counsel is the judiciary. It's all simply taken as axiomatic that the only remedy has to be damages because the condition precedent was not in fact satisfied. In my submission, that's quite right, just as a matter of normal principles, because it's what the contract said. The contract didn't say if there's a breach, you can simply ignore this condition precedent. Next point I make about Luxor and Cooper is that in that passage, Lord Russell, with which Lord Sankerson agreed, where he said that subsequent acts would not deprive the creditor of an accrued vested. He did not confine the acts of which he was speaking to breaches by the debtor. He expressed it broadly in terms of act or omission, not breach. And he referred to act or omission of any party, not just act or omission by the debtor itself. And I asked the court to compare that with the principle which is advanced by the sellers. The sellers' case, as it's ultimately advanced in their skeleton in this appeal, is that there is a single general principle. It applies to conditions precedent to the accrual of debt, and it applies to conditions precedent to the payment of an accrued debt. And it is engaged in both situations when actual satisfaction of the condition is prevented by the debtor's breach. Debtor's breach is the trigger for the principle. I would respectfully submit that when you look at the passages in Luxor, they indicate that the debtor's breach doesn't really come into it at all. What they indicate is that if a condition precedent to accrual of a debt is not satisfied, then there is no debt, breach or no breach. If there's a breach, there is a claim, but it's a claim for damages. But the breach does not make the conditional debt magically become an unconditional debt. By contrast, if the debt has vested, it stays vested, breach or no breach. The subsequent conduct of the debtor cannot divest a vested debt or extinguish it, even if it doesn't involve any breach at all. And that's illustrated by the Karen Vatis case, which is in tab 16 of the authorities bundles. I'm not sure we need to turn it up, it's quite well known. That's the case where the freight is earned on shipment, but it is not payable until after discharge. So it's plainly a debitum in praesenti, solvendum in futuro. And the condition precedent for payment is completion of discharge. It became impossible to satisfy that condition precedent because the ship sank. It never arrived. The cargo was never discharged. There doesn't appear to be any shred of a suggestion that that was down to any breach of contract by the shipper. Indeed, any indication that it might have been relevant whether it was or not. The simple approach was that the debt was vested. A vested debt doesn't just disappear in a puff of smoke because a condition precedent to payment becomes impossible to fulfill. The condition precedent to payment is treated as mere machinery. And the freight was paid, became payable. The critical issue in the case was whether or not the freight had vested, not whether or not there was any breach. Once it was vested and it stayed vested. Now, strictly speaking, the law might, in a case like that, it might take a very strict theoretical view and say, well, okay, if the condition precedent to payment becomes impossible, then you'll still have your debt. And you may be able to use it by way of set-off, but you'll never be able to enforce it because the condition precedent to payment will never arrive. And so you'll have this notional debt, but you'll just not get hold of the money. So the law might take that very strict, formal, logical view. But for most practical purposes, aside from things like set-off, that would be tantamount to saying the debt is extinguished if the condition precedent to payment becomes impossible to satisfy, because you'll never get your hand on the money. That would be the substantive effect, and that would substantially contradict the principle that once a debt has been vested, it can't be extinguished, unless you undo the entire transaction. On the contrary to principle, it would also be profoundly unsatisfactory, if as may well be the case, the reason that the debt has accrued is it's accrued on performance by the creditor of some act or service for which the parties plainly intended that the creditor should be paid, and the condition precedent to payment has been inserted for the benefit of the debtor. To take hypothetical examples, a contract to repair a ship or to provide waste disposal services, where the contract provides for payment to be made in arrears as the work progresses, as the work is done. And there is a condition precedent which gives the debtor the opportunity to inspect the quality of the work before it has to pay, or to check the arithmetic in the invoices before it has to pay. It would be very difficult to justify a conclusion that a breakdown in the inspection or verification mechanism, death or refusal or disability or whatever of the engineer or the surveyor, means that the creditor just never gets paid for the work which has been done, because the condition precedent to payment can't be fulfilled and the debt can become payable. And it would be little consolation to tell the creditor, well, you've still got your debt, you can use it by way of set-off, but you're just not going to get your hands on the money. And not surprisingly, the law has never taken that very, very strict view, that if there's an accrued debt with a condition precedent to payment, and it becomes impossible to satisfy the condition payment, then the debt never gets paid. It takes the view, at least generally, that the condition precedent to payment is mere machinery, and if it breaks down, then a debt will still get paid, and if necessary, some other machinery will be put in to replace it. And there's an analogy with the Sudbrook and Eggleton principle about putting values on things. If the parties are still negotiating, then if they fail to agree the price for the goods or the rent for tenancy, then that's probably going to mean that the court will conclude there's not a contract. But if they've concluded a contract where they haven't fixed a price or a rent or other value, but the contract contains a mechanism for fixing it, reference to a surveyor, expert, then a failure in that mechanism will not mean that the contract is discharged and that no price or rent becomes payable. Again, the law takes the position you've got a contract here, you've got accrued rights. If the mechanism breaks down, it's simply treated as non-essential machinery. And if necessary, you come up with some other machinery. And again, that doesn't turn upon breach by anybody. The principle that breakdown in the machinery does not divest vested rights has got nothing to do with breach. The thing that causes the breakdown may be entirely extraneous, nothing to do with breach by anybody, as in the Karen Vatis, ships sunk by a storm at sea. And so, pulling the threads of that together, I submit that it is not the case, as the sellers would say, that there is a single unified principle which applies with equal force to accrued debts as to debts which are subject to a condition precedent before they even accrue. Different principles apply to different categories of case. If there is a condition precedent to the accrual of a debt, the debt does not accrue unless and until the condition is satisfied, in fact, breach or no breach. Where there is a condition precedent for payment of an accrued debt, the debt does not divest by failure in the mechanism of payment. And again, breach or no breach. So that I submit is the broad legal position, and then applying it to this case. This is not a case about conditions precedent to payment of an accrued debt. This is not a case of debitum in praesenti solvendum in futuro. The conditions precedent here attach to the accrual of the debt. I emphasise that point. I hope it's clear to the court, but I emphasise that point because the opening of Stella's skeleton argument with respect puts it a little imprecisely. Paragraph 2 of the skeleton says this: the critical question is where, one, a contract provides that a party must pay a sum of money when only when some condition is satisfied. 2, that party in breach prevents the condition from being satisfied. Is the condition in question deemed to have been either waived or satisfied? And having put the question that way, the seller's skeleton at paragraph 3 says that the majority in the tribunal answered that question yes. Now, with respect, that's not quite right. The majority in the arbitration didn't really answer that question at all, because that's not the way the question was put. The way it was put can be seen in the bundle in tab 7, paragraphs 29 to 30, which is, I think, page 85. My learned friend, I think, showed you these passages, but I just want to highlight that the case is put in 2 alternative ways. The first case in paragraph 29 is what is described as the general principle. That's deemed waiver or satisfaction, relying upon Mackay and Dick and Loga, and also referring to the Leonidas. That general principle is said to be justified by the consideration that a party must not be permitted to derive an advantage from its own breach of contract. I will need to come back to that broad proposition later. The court will note that Panamida and Leyland doesn't feature at this point. Paragraph 30 then puts the alternative case. And the alternative case is that the clause 2 conditions are not preconditions to liability, they're mere machinery. Reference to the Dominique and the Karen Battis. It's not expressly said, but the case was that the debt actually accrued immediately on signing of the contract. Merely payment that is postponed. So there are 2 alternative and mutually inconsistent cases are put. The first case, which is the general principle, presupposes that the debt doesn't accrue until the conditions precedent are satisfied. The second case, which is the Dominique machinery of payment case, presupposes that the debt accrues immediately on signing and that everything else is just machinery of payment. And the majority of the tribunal accepted the general principle, that is the first case, and that is at page 90, paragraph 36.1. They accept the general principle based on a factor. That is the conclusion against which we appeal under section 69. And this is Justice Dias accepted our case, that there is no general principle, and therefore there was no claim in debt. And that is what the sellers appeal against on this appeal. Now, in the arbitration, the majority, having decided the case on the basis of the abacha general principle, didn't actually say anything at all about the Dominique alternative. But on the appeal to the commercial court, the sellers revived their Dominique alternative case in a respondent's notice. And the judge held that they were wrong about that. This is not a Dominique case because the clause 2 conditions genuinely are conditions precedent to the accrual of the debt, they're not mere machinery. That's in the judgment at paragraphs 101 to 122, pages 44 to 47 of the bundle. So the Dominique alternative failed before the judge, and there is no appeal against that. And so the position on this appeal is this is not a Dominique case. It is not a case of an accrued debt with a condition precedent to payment, which is mere machinery. The deposits were not debitum praesentem, praesenti solvendum futuro. The clause 2 conditions were conditions precedent to the accrual of the deposits in debt. And therefore the question on appeal before this court is again whether the general principle which is stated in the reasoning of paragraph 39 is correct as a proposition of law. That general principle is directed to debts which do not accrue unless and until the condition precedent is satisfied. That's rather more precise and specific than the way in which it's put in paragraph 2 of my learned friend Skeleton, because paragraph 2 doesn't draw that distinction between accrued debts subject to a condition of payment and debts which don't accrue until the condition is satisfied. Now, that's because, I suspect, as I said a few moments ago, on this appeal, my learned friend is now saying, well, they were wrong to draw that distinction. In fact, you treat all sorts of debts the same way.
No, it's also slightly different from the question of law.
I'm going to come to that in a moment, my lord.
Submission
I'm
to
going to
appeal.
come to that, the criticisms of my question of law. But they take that point, you treat everything alike, and the court's going to have to decide it. But I do ask the court to bear in mind that what you're ultimately being asked to decide on this appeal is whether the general principle, the abacha principle, applies in the case where the accrual of the debt is subject to a condition precedent. Now, my lord, I take on the chin that our formulation of the question of law in the Part 8 claim form might be said to be subject to the same criticism. It doesn't very clearly draw that distinction between accrual and not. And if you read it out of context without knowing what had been going on in the award, I would accept that one might wonder whether the distinction has been drawn. I do submit that if you read the award and you see the way that argued and decided, then it's reasonably clear what we're trying to raise by way of question on the appeal. I don't accept the criticism that we're wrong because this is not a case where we had to fulfill the condition precedent. My learned friend may be right that this doesn't matter, but I do submit that the relevant condition precedent here really is the promissory condition precedent by us that we would provide HFW with the documents. That's a promissory condition precedent, and as found by the tribunal, we were in breach of it. That's a relevant condition, that's a relevant breach. My learned friend suggests that the provision of documents to HFW isn't a condition precedent, it's just a practical step. He says the condition precedent is the confirmation by HFW. It may not matter, but I do submit that's not really very tenable. The deposit is not to be lodged until HFW confirm that the account is open. HFW can't confirm that the account is open until the KYC documents are provided. The obligation to provide the KYC documents isn't triggered until the contract is signed and exchanged. So these are all conditions precedent building up the ultimate step in lodging the deposit. And the judge took the relevant condition here was a promissory condition precedent that we would provide the documents. That's the obligation which we are in breach of. Mainly we prevented fulfilment of that condition precedent because we just didn't do it. And if to the extent it does matter, then I submit that the way we formulated it in the claim form is right. And that it was a condition, a relevant condition did have to be required by us. But I can see that maybe it doesn't. So well, to that extent, I do accept that the way we formulated in the claim form might have been tighter. But I hope that the court appreciates that the specific question is there a relevant general principle which applies in the situation where the condition precedent is a condition precedent to the accrual of the debt? That is the specific question before the court on this appeal.
Well, would you, and I may mean both of you here, like to see if you can come up with a more precise formulation so we can see what the, in the light of the way the point is going to be argued in this court, we can see that it is specified in the question of law, and so that we can be satisfied that as a matter of jurisdiction, and I think it is a matter of jurisdiction, it's sufficiently close to the original formulation that it comes within the leeway that I've been talking about. Mr. Justice Hamlin and Mr. Justice Eves identified in those cases whose name I still can't remember, I'm afraid.
Well, yes, we'll do that. I'm afraid I'm slightly over on the time for today, but
No, that's a given. And are we on course to finish comfortably tomorrow?
my lord, yes.
Just before you go, to save you having to search around for it, Rule 14.2 of the Insolvency England and Wales Rules 2016 provides that all claims by creditors are provable as debts against the company or bankrupt, whether they are present or future, certain or contingent, ascertained or sounding only in damages. And then there are certain exceptions, but that's the general rule.
Thank you, my lord.
So I don't think that actually helps the argument one way or the
One way or
other.
the other, my lord, I suspect that's probably right.
Thank you. All right, 10:30.